Sharp is our main presenter today. He's got lots of letters after his name, as you'll see, as it identifies him as having a lot of experience and qualifications in data privacy and data protection. Sharp is a principal privacy practitioner at Online DPO. He advises organisations on data privacy regulations and practices, and also does training throughout UK and Europe on data privacy laws to help data privacy officers and data privacy teams get to grips with all of the compliance regulations require of them. We'll then summarise the main presentation and then dive into the Q&A section of today's event. So just as I promised, here's the little sales introduction to Rangoon to let's tell you a little bit about us. We're a relatively new organisation, founded actually with a merger of two organisations that had similar mindsets and similar goals. But in 2016, that founding objective was to be a leader and be able to deliver high quality GRC, SecOps and data privacy solutions. Specifically, we work on the ServiceNow platform, but we have a lot of subject matter experts in the area of governance, risk, compliance, SecOps, but also more specifically the data privacy side of things. We've actually, as you'll see there, in terms of our credentials, in that time I believe that's now that 99 plus is really over 100 now projects that we've delivered or are currently engaged with clients across all continents pretty much, and that's across multiple industries and those different geographic territories that we've drawn your attention to. So I just wanted to tell you very briefly about one of our solutions that we've developed, which identifies and helps address some of the challenges that data privacy teams may face on a daily basis, and help them to bring control and automation to some of the key tasks that they might be looking to handle. So the solution is called GDPR Accelerator. And this solution is built on what we like to term this best of breed automation platform. If any of you know of ServiceNow or are ServiceNow customers, you'll know that ServiceNow have an excellent solution that is built on a solid database with workflow and automation and business rules applied to that can help automate pretty much any business task or operation. Well known for their delivery of IT service management technologies. They've branched into other business processes such as HR, governance, risk and compliance, SecOps, customer service management, etc. So our technology is based on this already well-proven platform to help drive and enhance business processes using technology. So our solution automates some of these key GDPR processes. You'll see in the grey circle there that some of those that we have today, we have a module that covers the data privacy impact assessment. We also cover the data subject rights requests or subject access requests, as they're formerly known. We also have a module that covers the Article 30 requirement of GDPR for the ROPO or record of processing activity. And then we have a data breach reporting capability for providing individuals within the business the ability to log a potential data breach, and then for the data privacy team to be able to investigate the severity of that and make sure that they start or meet the requirements for SLAs in terms of reporting to the regulator and also to any affected data subjects. One of the new features we also have in our version 3 of the product is what we call our legitimate interest assessment. And then we have a general ticketing system where people can register questions or complaints to the data privacy team as well. So as I said, it's a solution that fully automates these processes. So it has workflow behind it and has the ability to automatically assign tasks and track the completion or where we are with those tasks throughout the journey, so that anytime we can see where we are against the process. One of the other new features we have is a detailed DPO dashboard, and this is a dashboard for the data privacy team to be able to get a high-level picture of where they are in terms of any subject access requests, DPIAs, etc. It's high-level dashboard that you can drill down and get further information. As well as that, we have the end-user portal to enable all end users within your organization to get a touch and feel of that data privacy process, so they can log their own subject rights requests and have a look at what the process behind those, where they are in terms of any queries, and also the ability to raise questions to the data privacy team, and also log any potential breaches that they may be aware of. So as I promised, that's the pitch. That's the initial introduction to Rangu and who we are. I'd like to now hand the time over to Sharp, who's going to address the main part of the presentation, GDPR is compliance enough. Over to you, Sharp.
Thank you, David. So we've got about half an hour or so to go through this, so I will jump straight into this. And as any presentation, it's always good to start with some stats from external bodies. And I'm looking at here from Call Credit, and I'll jump into the others as well, from Forrester Report, and these were from 2017, 2018. Now, why I've brought these up straight away is just to look at what are some of the expectations of consumers in terms of whose personal data we're using. And the first one sort of kind of highlights, I hope, that there is an expectation from consumers or a comfort in the fact that this area is regulated. And by affording protection to them, they are more likely to share information with those organisations. The second 2 points from the Forrester report I find exceptionally interesting, on the basis that you can see from those that data protection is nuanced. And what I mean by that, it is not a binary choice. It is not just on off. It depends on the circumstances, and it's a dynamic situation. So individuals will be more willing to share information with organisations based on the exchange of the benefits they will receive. However, they are also expecting that those organisations will demonstrate and protect their data as well. So this is a nuanced area that we're moving into. And if you consider that those reports are from 2017, 2018, certainly now, as I'm sure everybody's aware, data protection is becoming a bigger issue. There's more focus on it. And when I speak to people generally, not necessarily in a business capacity, but just in a personal capacity, I definitely feel that people are becoming more aware of how their information is used and what their expectations are about how their data should be protected. So, that's the sort of theme, really, that there is an expectation and a requirement being driven from individuals. So if we jump forward a little bit, what is GDPR trying to achieve? So in essence, it's 7 principles and to ensure data subjects' rights. So why am I talking about this? Well, there is a problem sometimes, or there is you can fall into the trap of looking at the detail or the minutiae of the regulation, and therefore starting to obtain what I would call compliance myopia, where what you're actually doing is, are we meeting that article? Are we meeting that recital? And that's not unimportant. That's absolutely important. But let's remember that those articles and recitals are to drive the principles and to ensure those data subjects' rights. And you can see them listed there. So in terms of compliance, where does compliance fit into this? Well, it touches all of those principles, but certainly the accountability principle of GDPR is where we can find the compliance sort of area we need to meet. And I'll dive into that a little bit more in a moment. But ultimately, all of the articles, regulations, and everything we put into place are to drive those principles and to make sure that those data subjects' rights, whether they're fundamental rights or more nuanced rights, such as data portability doesn't apply in all cases, they can be effectively used. And remember that GDPR is there to encourage individuals to actually use their rights. So there will be more, I would suggest, moving forward over time. We'll see more of these rights, such as rectification, access, the objection to processing, being sort of wanted, demanded almost by data subjects. So really, I just want to set that scene of what are we trying to achieve with the regulation rather than just meeting the regulation in itself. So I did say I'll talk a little bit about the compliance and how we get to our compliance piece, really. And this we can look at in terms of Article 24 of the regulation. And if we take some of those elements out of Article 24 and look at them in a bit more detail and break them down, we can see those elements which sort of leads us to build up our data protection program in order of demonstrating compliance. So you can see point 4 there, is it, or 5, where we talk about demonstrate. So records of controller and processing available to supervisory authority, review and update. So this is, and continuous improvement. So this isn't a one piece point in time. It's not as though we meet a certain standard and then we stop. This is about continually improving and adapting to the way in changes in the expectations of individuals, as well as how the organisation changes. So I'm sure of the organisations that perhaps you work in or you represent, you will know that there is constant change in how that organisation is going to process data, new products, new services, new markets, etc. So your data protection program and the compliance element of that, which can be sort of extrapolated from Article 24, needs to be adaptable, needs a process for constant change and improvement to meet both the organization's requirements as well as those from the individuals. So if we look further and we move forward, I just want to talk a little bit about this compliance piece on how we achieve that. So this really is the types of way in which we can look at a compliance model. And I want to look now at the legal model or the compliance model, which is based on legal regimes and policy regimes. So what do I mean by that? Well, legal regimes can come from what is set down by governments. So we have the union law in terms of GDPR, and then we have member state interpretations of some of the elements of that regulation as well. Then we have policy regime, and this is the internal policies of the organization. So this could be your data protection program. And I think it's also worth remembering that if you're using data which relates to individuals, which is provided to you by third parties, there could be contractual terms which have a data protection impact on that as well. So we need to be able to sort of balance that and think about, the statutory and mandatory regimes. And they tend to fall into two sort of areas, prescribed and proscribed. And that allows us a certain amount of flexibility. For example, in GDPR, we see that there is a flexibility around the security requirements of data, on how we should protect data from a security aspect, and it gives us that whole risk-based approach. In fact, risk is mentioned 74 times in GDPR. So understanding risk is a really important part of a data protection program management. So we need to think a little bit about that sort of, risk model which we're going to undertake and apply. And I'll talk a little bit more about that in a moment, about how we can start to think about risk, not just from the perspective of the organization, but from the perspective of the individuals whose data we are looking to protect. Now, the regulation refers to protecting the fundamental rights and freedoms of individuals. Now, that's interesting because when we talk about the fundamental rights and freedoms of individuals, where does that come from? What are we actually trying to protect? Well, from a European perspective, we can look to the Universal Declaration on Human Rights and the European Convention on Human Rights. And don't worry, I'm not going to go through all of those. I just want to pick out a couple of elements of those that are pertinent to data protection. And you can see that both the Universal Declaration and the European Convention on Human Rights talks about the right to a private life, including correspondence, etc., as does the European Convention on Human Rights. So we're now thinking, okay, so what we need to do is protect someone's privacy. So the regulation, what we're trying to achieve is actually around protecting someone's private life. And you can see also there, we talk about freedom of expression within those, both of those instruments. And that can also cause us an issue, because if you have a right to a private life and you have the right to freedom of expression, how are those balanced? Where's the line? Where's the grey areas? And that is part of our task, to be able to understand those and sort of nuance those and meet that sort of, how can I put it, that balance between the two. And they are recognised also within both of those. So in essence, we now need to start to think about, okay, if a regulation is there to protect privacy, what is privacy? Well, this becomes quite an area where we need to perhaps look at different ways of interpreting what privacy is, because privacy is a social construct. And it depends on who you ask as to what is privacy. So one of the first, how can I put it, accepted definitions of privacy is the right to be left alone. Came about from 1890 by Lewis and Samuel in the Harvard Law Review. And I think sometimes all of us can appreciate that right to be left alone, especially, you know, when perhaps you've had one of those, you know, days where everything's sort of been on top of you and you just want to be able to sort of say, you know what, I just want to be left alone. And interestingly, where did that come from? What was the pervasive or invasive technology that started that piece? Well, it was the introduction, or the you know, not the introduction, but the fact that the camera had started to become more widely used. And the camera was seen as a means of being an invasion into people's privacy. So if we think about what happened in 1890 in terms of what was causing concern with regards to people's privacy in a camera, where are we now with regards to the ways in which people's privacy can be invaded, potentially, how we can be observed? I mean, we've just looking at bringing 5G online, regardless of who that provider may be. In fact, it's already here. But when that really rolls out, what we're going to see is more areas of data collection across many disparate areas. So the ways in which data can be collected, and maybe sometimes in an obscure manner, will cause more of a privacy concern for individuals. So in terms of looking at it today, what methodologies can we apply with regards to privacy? Where can we look and how can we, you know, what can we look at? So I've put a few here, which, you know, we use. One is sort of information flows, contextual integrity. And just to give you a brief sort of explanation of what I mean by integrity flows, that can be domain-based. So integrity flows tend to work on an individual would pass over information depending on the domain that they are in. For example, you would perhaps provide different types of information expected to be used in a different way within banking as you would perhaps in health or with a doctor. It's also contextual based. So not only does it depend on the domain in which information is being shared or used, it also depends on the context. So it depends, it's situational as well as domain based. Now that's important because that becomes very nuanced, especially in today's age, in, as I was saying, in the way that information can be collected and shared. The issue is that it's, how can I put it, somewhat obtuse, shall we say. So we need to find methodologies and a way to start to sort of work more closely in building a strategy to meet that. But there are others. There's Carlos's harm dimensions that we can look at as well. And that sort of gives us a bit more of an insight, shall we say, into how people's information might be used inappropriately as they see it, the appropriate use of that information. And he introduced one of the concepts of what is known as subjective and objective harm. So I just want to talk a bit about that as well. Subjective and objective harm, well, let's look at the subjective harm. Subjective harm falls into an area where it might cause psychological or behavioural change. And it's important that we address that on behalf of individuals. Because if we don't address that, it can change the way in which individuals will use the services or the processes that perhaps we are subjecting them to. So we need to think about the subjective views of the individuals rather than just the objective issues that could happen from how we're using their data. So what's a privacy invasion? So similar to the ways in which we can look at and see that there might be, you know, an invasions or security could be invaded, there are also ways in which an individual's invasion can be invaded. Now, I want to look at for a moment a taxonomy of privacy problems. And in a way, this is quite useful because a lot of the work has already been done for us in this area. And this was done by looking at various industries and looking at just not just the legal invasions that could happen, but the behavioural, the psychological types of privacy invasions that could occur for individuals. And I'll look at that a bit more on the next slide. But as well, we can see I've discussed the contextual side of things. I've looked at the subjective and objective harms, as well as, you know, I put in there FIPS, fair information processing or practices and principles. And that sort of dovetails into the compliance model. So the compliance model, i.e., are we meeting our regulatory and policy requirements? The FIPS model also sort of dovetails into that. In fact, it's been sort of used by the FTC in the US, as well as the Department of Homeland Security in the US. But there is an issue with that. And the issue is this, is that if you just focus on the compliance model, and as an example, the FIPS model, some privacy invasions can slip through the net. So therefore, we might need to start looking at a combination of models to understand how someone's privacy can be invaded. So it's looking at perhaps almost certainly the compliance model, because compliance is the baseline of any data protection program, but it is an element of the program. It shouldn't be the goal of the program. We also need to consider those subjective objectives and, as I said, those contextual parts of how information is shared depending on the name or the domain and the nature of how that information is being shared. So if we look at the the taxonomy of privacy problems, you can see there that it's been broken down into four main areas, okay? And within those areas of a type of invasion that an individual could suffer, from the way in which we are using their information. So it could be breach of confidentiality, disclosure, distortion, as you see there, intrusion. You can see there's interrogation. Now, when we talk about interrogation, we're talking about interrogation, perhaps asking inappropriate questions on an interview situation, or it could be interrogation from not allowing someone to use the services we're provided unless they give us information on a website. So that's what we mean by interrogation, and the forms of interrogation that could be used in that instance, just to sort of highlight a couple of those. But it gives us a sort of basis of sort of thinking about, okay, where can these privacy, and what are the types of privacy invasions that individuals could suffer based on what we're doing. So if you're now looking at these models, you've got the compliance model, FIPS, you've got the subjective objective, you've got the sort of information flows. What I would suggest is that you don't use all of them, because there's a diminishing return in that. But you choose those that give you the best results, that work best for you in your organization. And as we can see, you can see that we're trying to look at in terms of mitigating these. So the next piece is, how are we going to mitigate these privacy invasions that could occur to the individuals? Well, really, this is where our best tool, shall we say, is the DPIA, or Data Protection Impact Assessment, as it's referred to in GDPR, or more commonly referred to or seen as the Privacy Impact Assessment. So to be clear, GDPR gives us the mandatory requirements that should be included in a data protection impact assessment, as well as certain triggers as when they should be undertaken and used. However, that is the mandatory requirements that a regulator would want to see in them. There are other methodologies or advice on how they should be completed. And what we've done is we've looked at, okay, what other advice is out there? So there's advice from the Working Party 29 group, the UK's regulator, the ICO, CNIL in France, which has extensive advice on this, 4 volumes advice, as well as more process-driven ISO 29134 can also guide us in what should be included over and above the mandatory requirements, and ways and methodologies and approaches in completing these. They're not the only ones by any stretch of the imagination. There's various others that you can look at to seek advice on this. New Zealand Privacy Commission, US Department of Homeland Security, Hong Kong, the Treasury Board of Canada. All of those provide a lot of advice and methodologies on completing the Data Protection Impact Assessment, or PIA. And this is a useful tool for us. In fact, it's probably one of the most useful tools we have. Why? Because first of all, it allows us to start understanding and identifying where those problems can occur. So we've already looked at understanding what are the invasions, and of course with anything, just because we have a list of potential invasions, we still need to consider things such as the motivation behind that invasion. Could it be blackmail? That sort of thing. What's the capability of a threat actor behind that invasion? And then we can start to build up, and there are again various ways, and we can start to assess this. Then we can start to build up our solutions, and in terms of reducing the risk of a privacy invasion to an acceptable level. So how do we start to do that? How do we start to think about how we've identified the risk, we've looked at potential risk, not just from the compliance model, but also from the view of the a subjective harm, those taxonomy of privacy issues, in terms of the context of the way the information was given to us. Was it given to us directly? Was it given to us as a trusted advisor or user of information? or are we handling that information as a secondary user? And those start to change, and we can start to see invasions with regards to the breakdown of those norms, those information normal flows, and the expectations of individuals. So once we've identified that, we can start to then think about how can we start to mitigate those privacy risks? What are the strategies we can start to deploy to reduce those risks to an acceptable level for the individuals, not necessarily for the organisation, because that is not the function of the DPIA, but for the individuals? And it brings us on really to a large area which is growing, which is privacy by design. And this is referred to within GDPR as data protection by design and data protection by default. But it does come from privacy by design. It came around in the sort of 1990s from the Canadian commissioner at the time. And it's a set of 7 principles, and you can see those principles there. With regards to the adoption of privacy by design, the new Indian data protection law is pretty much taking those principles and using those as the foundation for the new data protection law in India. And other international organisations have accepted these and are using these as a foundation for their regimes and requirements. But as all things within data protection and privacy, it has its critics. And those criticisms, to a degree, are valid. And they are valid in the fact that they are principles. So where's the methodologies? How do you build on those principles? Well, there are techniques. There are more sound ways of applying those or underpinning those principles within the design system. So I'll just pick out a couple of those. So if we talk about privacy being embedded into a process or a piece of software or application or an organization's approach, what we mean by that is that privacy cannot be circumvented with regards to a process or software application. So we're seeing this, really gaining some traction now in software development. Privacy engineering and building privacy by design into software solutions is a real growing area. So one of the examples that you can use is, if you think about a kettle, which doesn't allow itself to boil over. If it gets too hot, it runs out of water, it switches off. And the only way you can get around that functionality of the kettle is to get a screwdriver, take it apart, and take away those thermostat and those switches that prevents that happening. And that's the same approach with regards to privacy being embedded into your process or your software development. It cannot be moved around. You cannot get around it. And also thinking about this whole piece around, it's proactive prevention, thinking about this from the start. So when you're designing a system and you're thinking about privacy by design, this isn't the afterthought. If a core requirement, if a core functionality of the design of a system should be, okay, this is what we're trying to achieve, but we're also trying to achieve privacy. That is part of it. It's not an afterthought. It's not something else that should be a consideration. It is from the design stage of a functionality. Now, I just want to caveat privacy by design. And I don't want anyone to think that I'm down on privacy by design. I'm a great believer in this. I think, we need to embrace this and use this more and more in the way in which we approach our systems of processing as well as software development, etc. But I just want to caveat this, because if what you are trying to achieve is in itself a privacy invasion, for example, if you're looking at surveillance of employees or individuals, that in itself is a privacy invasion. It doesn't mean we can't use privacy by design. What it means is that we can start to think about making a system more privacy friendly, shall we say. So we need to start thinking about how can we make this system more privacy friendly for the users. And I just want to sort of end this really as to why. Because if we're talking at privacy by or design or privacy within the regulation in GDPR, again, I don't want to fall into that compliance requirement, and that being the only reason to consider it. So there are other issues around this, and a couple are just to highlight them as to why we, as data protection professionals, need to be considering privacy by design, is around the asymmetrical power, or as it's commonly referred to, the imbalance of power between individuals and organizations. And we see that a lot with regards to employer-employee relationships. But it's not only that, it can be councils with, individuals that they are representing. Also, it's worth considering as well what's known as asymmetrical information. And asymmetrical information is where there's an obscurity in the provision of transparency of how data is going to be used by organizations. And from my view, I don't think this is going away. I think this is going to become a much bigger issue as we move forward. Because as I've said, there's more and more ways in which information can be collected, used, combined, etc. Just to round up on that one, there's also a couple more in terms of cognitive biases, such as hyperbolic discounting and empowerment by the individuals. So those are areas where people, for cognitive reasons, can't make those choices. It's a bandwidth issue. I think statistically speaking, the average person in the UK, if they had to read every privacy notice with organisations on information they share, it would take them 11 months. So the bandwidth for individuals to do that and then make the assessment as to whether they're comfortable on how that information should be used is difficult. So I'm just going to sum up now in terms of why compliance is a requirement. Well, it feeds into individual expectations. It's part of that process of individual expectations. It may be contractual requirements. You might need to demonstrate compliance in order to meet contracts, and it could be a defensive position. If I'm compliant and I'm going to be, perhaps taken to court, I can defend myself. I can, demonstrate that I'm compliant. So I just sort of sum up there or think, is that a great message for people? Is the message, you know what, if you want to take me to court, you won't win because I can demonstrate I'm compliant. Not sure if that's the greatest message. Whereas if we move towards stewardship, we start to develop trust. It increases our brand reputation, and it allows us perhaps to get a competitive advantage in the market. So that's another area why we should move from compliance to stewardship. But remember, it's not a binary choice. It's not compliance or stewardship. In the same way in which security should be part of a data protection program, compliance should be an element of the data protection program as well. So I think I hopefully haven't gone over too much time there. There's some time for questions. Thank you for listening, and I'll hand you over to David. Thank you.
I just wanted to kick off. Thank you very much, Sharp, for going through that presentation. An awful lot to take in there. The opportunity is for folks to now enter any questions in the question box. I'd like to just start off with one initially, Sharp, and that is, in your experience, is there any evidence to support that organisations that have sort of transitioned from just being compliant to embracing this more from I guess a culture wanting to support their customers or data subjects? Has there been any evidence to show that that's improved their business or their customer relations, whatever it may be?
So I think if you want to look at something anecdotal, you could look at what happened with Sony when they had a breach and they handled it so well. It actually improved their adoption and customer, shall we say, interaction. From my own personal experience, being really brutal about it, I try and get this message across early on in the engagement, so we all know what we're trying to achieve and where we're heading. For my engagements where I've dealt with organisations that perhaps have taken a more myopic view of just sort of achieving compliance, very quickly, and well, relatively quickly, within sort of 6 or 7 months of the program adoption, um, you start to find that organisation, in fact, different elements of the organisation, such as marketing or from the senior leadership, the C-suite, start to say, you know what else can we get out of this? Because everybody's talking about data protection. And in fact, if you look at the latest adverts that are coming out from, say, someone like Apple on the television, what they're saying is privacy. That's their message there. So I think it's more of a growing and awareness within organizations.
Okay, great. And that kind of leads me to the next question then, that you mentioned about privacy notices coming up and the fact that I guess there's a high percentage of folks that don't read those all the way through,
Yes.
just accept them. What is, you've kind of mentioned something that Apple, for example, are doing, but what are things that organizations can do to help people know that they take privacy seriously rather than it just being a tick this box to say you accept our privacy consent notice?
Yeah, that's a great question. So I think if we jump back really just to answer that, in terms of providing notice, there's lots of different ways you can provide notice. Um, and it's around the transparency principle of a regulation. For example, on your phone, there is no mechanical part on the phone. But when you take a picture on your phone, there's that click sound. And that is a form of notice as to what you are doing. In fact, in Japan, you can't turn that facility off. It's a legal requirement. What you want to do is, if you're going back a step as well, looking at privacy by design is sort of saying, okay, you don't need to trust us in terms of what we're doing with the information. Trust the system. We have built in an architectural solution as well as policy and point solution, but architecturally we have built your privacy into it, so we consider it. So in terms of a regulatory requirement, yes, there's the privacy notice, mandatory elements that need to be in there, various delivery methods, etc., etc. I think it's more about the point, really. This is a marketing piece where an organization will say, we build privacy into what we're doing. This is, and it's not just words. We have a methodology, a system, an approach. We can demonstrate that we're building privacy into the processing and software applications that we use.
Wonderful. And that actually segues very nicely into the next question we've had in, and that is, do we need tools or software for privacy, or is it an attitude only? Are there tools out there that that can help embrace
That's a
privacy
good question.
culture?
So I think there's two areas here. If we look at the US model, the US sees that privacy will be achieved. They're looking heavily on tech vendors in order to manage and meet their privacy requirements. In Europe, it's slightly different. In Europe, we take a more policy-driven approach to protecting individuals as well. And policy really is about a change of culture and, as you said, attitude. To me, the solution's somewhere in between. The proof tech market has exploded. So you need to be able to nuance and understand whether technologies are actually privacy enhancing for you, or if they are even perhaps privacy disruptive to you. So being able to assess what privacy technology will assist your program is an area in itself. So I think the answer is probably somewhere in the middle.
Great. Okay. Thank you for that. And perhaps I could just add something to that question as a vendor of privacy management or data privacy management software, one of the things that we've seen people very quickly be able to embrace is where a solution like Rango's GDPR actually enables people throughout the organization to be involved in that privacy process. What I mean by that, it doesn't just become the task or the ownership of the data privacy team. For example, project managers, infrastructure managers, application managers, if they're managing their configuration items or assets that are holding or hosting personal information that might be sensitive, the tool makes sure that all of those people are involved and know their responsibility. So right from the carrying out of the DPIA to a new project manager, this concept of privacy by design. We're launching a new application. Immediately we can build into the automation of that they've got to consider the data privacy aspects, and it starts to drive them through that process. And also with the employees or the staff or the customers, the data subjects, where they get to interact with the data privacy team directly, so that they can see that it is core to their culture as a business.
No, you're absolutely right, David. I think one of the biggest, not one of the biggest, but a concern that I have when I've been implementing or aiding organisations implement data protection programs is about getting buy-in. So what I mean by buy-in is even, people starting to think about privacy, think about data protection, because ultimately it touches all areas of an organisation. And therefore, if a data protection solution, whether that be management or something more pointed, can facilitate and aid in, getting that cultural understanding of data protection, that's not a bad thing.
Great. Okay. So I think we're pretty much there. If anyone else has a question to ask, if you want to type it quickly into the message box on the bottom right of your screen, you can just type it in and submit it. We've got a couple of more minutes just to wait there. Anything else that you'd like to add, Sharp, just while we wait to see any more questions?
No, I mean, I would say that I think what I've done there is cover some quite big topics in themselves very quickly. So, each of those sort of areas I've touched on in itself, would deserve some sort of level of engagement. So I'm sure that, if anybody wanted any more details on that, feel free to reach out to David. I think your details are up there, your email's up there, David, on the last slide. So if there's an area where you sort of go, okay, I was interested in that, but you sort of went over it very quickly, and I appreciate I did, then feel free to reach out to David, and I'll be more than happy to help.
Brilliant. Thank you, Sharp. Thanks so much for everyone else for attending our webinar today. As Sharp said, our contact details are there. You've got my email and phone number if anyone wants to reach out to me for any more questions that you may have, or if indeed you'd like to have a look at some of our offerings, or perhaps have a chat with Sharp about what he can do to help engage in your data privacy process and practices in your organization. Thanks, everyone.